One of the things that GoMart looks for is a company that is going to provide us with the best coverage for the best premium that we can get.
When you look at the overall picture, the partnership that we have with GoMart is working.
Working with Brick Street keeps our employees and customers safer every day.
You know, at the end of the day, that's what it's all about.
Thanks everyone for coming. It's great to be back in Huntington. I live outside of Huntington, but I grew up here. I lived 2 blocks from here is where I grew up, so I used to walk through this parking lot every day to get home from school. I graduated just across the street, so it's great to be back here. Recognize a lot of familiar faces here who I've worked with over the years. Before I get started, several of my colleagues came down to join me today from Brick Street. I just want to recognize them. I'm not sure if they came because they do not get to spend enough time with me during the workday or they want to heckle me. I'll let you make that determination. But along with Lisa's, Melissa Blatt, Lisa Hamrick, Samantha Jeffries, and Bill Freeland, who came down to join me today. So thank you all for taking time. I know you all have very busy schedules and I appreciate it. So let's talk a little bit about drug testing in this new West Virginia Safer Workplaces Act that just was enacted the last legislative session and became effective July 7th. So this is law now. You employers in the state do have the benefits of this law now. Tremendous change in West Virginia, something in my opinion that has been long overdue. The ability to drug test in West Virginia was very limited, as most of you know. I'll talk a little bit about that and how we get to where we are. But how many people, just give me a show of hands, think that drugs are a problem in the workplace today? Absolutely, they are. I mean, and if you look, I'm going to show you some statistics here that just astounded me when I was looking these up. 70% of estimated use of illegal drugs are employed. That's astounding to me. 70% of your workforce have admitted to using illegal drugs at some point in time. The top 3, marijuana, cocaine, and strongly gaining ground are prescription medications. Look at this. 24% of workers have reported drinking at least once during the workday in the past year. 1/4 of your workforce has admitted to drinking at work. So look around, the 4 people, 1 of you have drank alcohol at work in the past year. Okay, Brick Street table, which one? And how is this relevant? Well, drugs or alcohol in the workplace cause 35% statistically of all injuries that occur in the workplace. 38 to 50% of your workers' compensation claims result from alcohol or people being under the influence of drugs. So it is a tremendous problem in our country. You know, we all see the stories in the news about the opioid abuse and et cetera, but this does hit home when you're trying to manage a workforce. And now, under this new Safer Workplaces Act, you as an employer will now have the ability to do some drug testing. It's amazing how we have gone to the limitations we had in West Virginia to how broad this new legislation is and how much power it actually gives you as an employer to drug test your employees now. Could this perform at 67% of the potential people who are under the influence of drugs or alcohol, and probably no surprise, but think of the productivity that we are losing as employers, slightly, probably more than we do during NCAA tournament time in March when people are playing their pools. All right, how did we get to where we are? Well, back in 1990 is when West Virginia first addressed drug testing in the state. It was a Supreme Court case called Twigg versus Hercules Industries. Those of you who have practiced law in this state are very familiar with this case. It's been our law since 1990 and still has some application today. So don't get rid of Twigg, especially if you're a public employer. It still has some application today. In this case, Hercules Industries manufactured highly explosive fuels. Mr. Twigg was an employee there. He has assisted in the maintenance of stock. Now, if you read this decision, it talks about his job required him to be in all parts of the plant. And Mr. Twigg got injured at work, had previously submitted to a couple of prior tests that his employer asked. They were random tests. And he had submitted, and the third time, as a charm, Mr. Twigg said, no, I'm not going to submit to your drug test this time, Hercules Industries. So what did Hercules Industries do? He terminated Mr. Twigg. He filed a lawsuit. We get the holding from our Supreme Court in 1990 on this case, and our court said, guess what? It is an invasion of privacy to drug test someone in the state of West Virginia. Now think about that, folks. You as an employer trying to create a drug-free workplace, our Supreme Court in 1990 determined it was an invasion of someone's privacy to drug test. Absurd holding, in my opinion. The problem was it stayed the law of West Virginia until this new act in 2017. The court carved out two exceptions in that case. One, if the employer had a reasonable, good faith, objective suspicion someone was under the influence. Talk a little bit about that in a second. What is a reasonable, good faith, objective suspicion? Second, if the person was in a safety-sensitive position, the court said that you can perform random testing on those individuals. The problem was the court did not give us a definition of what a safety-sensitive position was. Anybody's guess, right? I had some employers when I was practicing would argue, well, every position in my facility is safety-sensitive. I don't think you're ever going to get by with that argument. Interestingly enough, now that TWIG is almost all the way gone, this new act we're going to talk about in a second defines safety-sensitive position. I'm not sure what that was all about, but we now have a pretty good definition of what a safety-sensitive position is. Problem we have with TWIG, guess what? If you guessed wrong, what were you subject to? A lawsuit. So it chilled the efforts of employers to drug test because they were concerned about lawsuits. And there were a couple of lawsuits that ensued. What happened after TWIG? Not much. Very little guidance from the West Virginia Supreme Court or any other courts regarding what some of this stuff meant in the holding of TWIG. In 2003, we did get a case from the Supreme Court that determined that the TWIG holding did not extend to pre-employment exams. So the court allowed you to drug test your employees pre-employment, finding there was a less expectation of privacy prior to beginning work. So you could drug test those individuals. However, the court made it clear in that case, be careful, employers. This is a slippery slope you're going down. There was also a case some of you may recall it was against Walmart I think the person was stalking, if I remember the case correctly, and had a back injury and was ordered to undergo mandatory post-accident testing, filed a lawsuit, and it was decided that there was an invasion of privacy. I don't know what Walmart ended up paying in that case, but there was some damages awarded as a result of the drug testing in that case. So employers kind of shied away in many cases from doing drug testing because of the concern about the litigation that would ensue. In 2013, we got another case. Now, this was a memorandum of opinion, and what I mean by that, typically when you get a case that's making law, the Supreme Court justices will sign that case. There will be one justice who will have written the opinion. In a memorandum of opinion, you do not have that. But we had a memorandum of opinion, and it's questionable whether these can be used for precedential value for law or not. But in this case, there was a deputy sheriff, and he was required to undergo a drug test. The facts of the case were that the sheriff heard a rumor that he may be using illegal drugs. Court in this case said this was not an invasion of privacy because this deputy sheriff's job involved public safety and the safety of others. So we did get a little bit of guidance in 2013 from the court in the public safety area that perhaps the court would allow a little more leeway in testing in those areas because of the nature of public safety. So what happened following TWIG? Well, we had a lot more questions than we did answers. What is a reasonable, good faith, objective suspicion? I will probably, if I ask you your definition and I give you mine, it's probably going to be different. It was a very subjective. What is reasonable, objective, good faith suspicion? Anybody have any thoughts? I mean, those of you who drug tested your employees, what did you use as the reasonable, good faith, objective measure for doing so? An injury? See, and I honestly think that TWIG, a lot of employers did mandatory post-accident drug testing. I think TWIG did not allow that, and I know a lot of employers probably got away with that. I think TWIG prohibited mandatory across-the-board accident testing. Observation. Yeah, erratic behavior, people acting differently than they normally would. I always tell my funniest story on a reasonable, objective, good faith suspicion was we had a guy who came into work one night, and his supervisor smelled alcohol on his breath. Now, You probably know alcohol is one you have to be a little bit careful with because sometimes diabetics will emit an odor very similar to the smell of alcohol. But this individual smelled of alcohol. His employer sent him to be tested, and he came back at 0.18, well over the state legal limit. He was terminated and filed a lawsuit against his employer. And he admitted that before he came to work that night, he drank one beer. He said, I had one beer. Bill's sitting here shaking his head. What? No? Probably 8 beers. Well, we get into I started, had interviewed some witnesses and stuff and got a little information about this guy. And they told me that he probably did have one beer, but he drank the same beer every night, 30 minutes before work. It was a beer that only comes in a 40-some ounce bottle. It's called Steel Reserve. So before we went to the hearing, I stopped at the Speedway, the Go Mart off the Milton exit, went into Go Mart, paid it $1.67. I know because my client told me to charge it back to them, the $1.67. Bought the bottle of Steel Reserve, and it's like 40-some% alcohol. So yes, Bill, he did have one beer, but probably the equivalent of 6 or 7. So it was so funny, though, when we went to the hearing, and I had the bottle of Steel Reserve in my briefcase and pulled it out and set it up on the table, and that was about the end of that case. So what does one do to celebrate when you have a bottle of Steel Reserve beer? Well, we had a celebration in my office that evening, and we had the bottle of Steel Reserve, and for appetizers, we had cheese puffs and Slim Jims. So that's how one celebrates with a bottle of Steel Reserve. Safety sensitive, there's another question. What does safety sensitive mean? Define that. How would you define a safety sensitive job? About someone could cause damage to equipment. Is that a safety sensitive position? I don't know. Some people argue that. And every job in my plant, I have a very dangerous operation. I have a logging operation. Well, is every job in a logging operation safety sensitive? Probably not, but I can make some arguments that way. So litigation really chilled the efforts of employers to, in my opinion, appropriately drug test their employers. They were concerned about litigation and what might happen. And we always get tagged as one of the most difficult places to get sued in the country. And a lot of big damages come out of cases here over the years. So there was a lot of concern about drug testing. So now let's fast forward to 2016. This process of getting some legislation passed actually started in the 2016 session. The Senate passed a bill in 2016 to allow more drug testing in West Virginia, but the clock expired before the House could evaluate it and debate on it and get it passed, so it died. Fast forward to this year, both the Senate and the House was able to get this piece of legislation through, and it's House Bill 2857. I encourage you to get a copy of it. It is not that long. It's about 12 pages in length. You need to familiarize yourself with it. You need to know every single provision of that act because you're going to be required to follow it strictly if you want to use it and keep yourself out of court. It allows you a lot of flexibility with drug testing, but you have to strictly comply with every single provision of that act, so you do not want to miss any of that. So get a copy of it. I have it electronically. If you want to give me your email or whatever, I'll be happy to send it to you. But get it, read it. I think it is about 12 pages, right, Steve? Yeah, it's not that long. It became effective July 7th of 2017, so it's been in effect for 2 or 3 weeks now. Out of curiosity, has anyone here developed a policy yet in compliance with the Safer Workplaces Act? No one yet? There are a couple of good attorneys here who can help you out with that, I think. All right, the West Virginia Safer Workplaces Act, let's look at some of the basic principles of it. It still recognizes the right of privacy in West Virginia, but remember I told you Twigg said it was an invasion of privacy to drug test. This legislation finds, as a matter of public policy, that the right to privacy is outweighed by the need to create and maintain safe workplaces for West Virginians. So it is no longer an invasion of privacy to drug test in West Virginia. Secondly, it declares drug and alcohol testing consistent with the Act and written policies. You're going to hear me say a lot about your written policy today because that's very important that you have a written policy to comply with this act. But this new act declares it legal. You can have a written drug and alcohol policy. Broad sweeping liability protections too, but again, you have to dot all of your I's and cross all of your T's if you want those liability protections that accompany this act. Okay, who is covered by the Safer Workplaces Act? Well, first, all private sector employees. There is no minimum, maximum employee requirement. So if you have one employee, you are covered by this act if you are a private employer. Now, there are some exceptions. One is the mining industry. The coal mining industry has its own statutory scheme with respect to drug testing, so that is exempted from this act. Secondly, the West Virginia Alcohol and Drug-Free Workplace Act, people who fall under that are exempted. These are construction companies who do public improvement projects in excess of $100,000. They have their own act, which applies to contractors and subcontractors. Those folks are exempted from this act. So if you're doing public improvement projects for a public authority, you may want to look and see, look at the West Virginia Alcohol and Drug-Free Workplace Act. Finally, while I said TWIG still has some application, if you are a public employer, you are exempted from this act. It does not apply to public employers. By public employers, I mean the United States, federal government, state, political subdivisions. Please, if you have questions about any of this stuff, please feel free. We'll have some question time at the end, but please stop me at any time. Okay, what is covered by the act? Well, alcohol, and it defines alcohol as ethanol, isopropanol, or methanol. Drugs, any substance considered unlawful for non-prescribed consumption or use under the Controlled Substances Act. All right, I'm going to pretend I'm talking to my teenager right now. All eyes on me, put your cell phones down. If you hear nothing else that I say today, listen to what I'm about to say. The employer must have a written policy that covers their alcohol and drug testing program. Again, if you hear nothing else I say, you can leave now as long as you understand you have to have a written policy. That is key to this entire act, that you have this policy. And you're going to hear me say this over and over again today. It must be provided to all your employees and all prospective employees. Before you can take any adverse employment action against an individual, you have to have a confirmed positive result. We're going to talk about this stuff in a little more detail, but if you get a positive test, you have to have a confirmatory test that goes with it before you can take any adverse action against an employee. And we'll talk about this a little more. This act gets a little dicey with how it's going to interplay with the Workers' Compensation Act. But this act says employees may forfeit workers' compensation and unemployment benefits, see what I have in parentheses, if so advised in your policy. Again, it's very important that all this stuff be clearly spelled out in your written policy. Okay, the act goes through a bunch of different reasons that you can have for your testing program. Deterrence or detection of possible illicit drug use, possession, sale, or manufacture of illegal drugs, intoxicants, or controlled substances. And listen to this part. Any amount, any manner, on or off the job. As part of your policy, you control what amount is detected and what drug is actually detected. You have that much control under this new act. Investigation of possible employee impairment. Investigation of workplace accidents, theft, or other misconduct. So is post-accident testing okay now? Yes, it is okay now. But we're going to talk about, remember, we have workers' comp that's going to throw some kinks into this stuff, as it always does. Some other reasons: maintenance of safety for employees, customers, clients, or the public at large. Again, you're going to need to put this stuff in your written plan, what the reasons for your policy are. And I would just go through the act and enumerate one after another what the act says the reasons for the testing program are. Maintenance of productivity, quality of products or services, or security or property or information. So to protect your workplace. Productivity, if you think you're having productivity problems, that can be a reason for your drug testing program. It need not be limited to individual job-related impairment of an employer or prospective employee. So this is very broad. As you can see, there is a lot of availability to be able to drug test under this. All right, sample collection. What type of samples can you take? Well, the Act says the employers determine the type of the test sample. It's your decision. You can use urine, blood, saliva, hair. The Act says or any other part of the human body capable of detecting the presence of drugs or alcohol. Again, you decide. Now, we're going to get to this in a bit, but remember under workers' comp, it has to be blood, and I'll talk about that a little bit later. Collection must be done under reasonable and sanitary conditions. Here's the only other, if a urine sample is what you're using, the observer has to be of the same sex. And then you have to use reasonable procedures to guard against misidentification. And this is talking about the labeling and the chain of custody. You need to have labeling and chain of custody procedures in place to prevent misidentification. Okay, the employee must be given the opportunity to provide any information believed relevant, such as I'm currently on prescription medication, I just had surgery, I'm on this medication, whatever that may be. You have to give the employee the ability to give you that information or any other information they find that may be relevant. Now, the law says this requirement may be satisfied by providing for review by a qualified medical professional. So there's a way you can get to do that with a qualified medical professional. How about the confirmatory test? Well, these are required for remember, if you want to take adverse employment action, you have to have a confirmatory test, so it is required. The Act tells us that there are three places that this confirmatory test must be performed: SAMHSA certified lab, CLIAS approved lab, or College of American Pathologists approved lab. I'm sure probably most of the labs you use to do this already fit under this, but just make sure whoever you use to test your samples fit under one of these three categories. For drug tests, a confirmatory test must use a different chemical process, and it has to use what's called a chromatographic technique. I have no idea what that is, so please do not ask me that question. So, actually, I brought some nice mugs to give away. If anyone can tell me what a chromatographic technique is, I'll be happy to give you one of these. There's got to be somebody here who knows. Any guess? You could lie to me. I wouldn't know. Just tell me something. No Googling. Now, and the other thing is that the employee, if tested positive, they can ask for a split sample. So they can ask for the sample to be split in two, and then they get to have their own sample tested. So that is available, remember, if the employee asks to have a split sample tested. Now, how about the cost of the testing? Who's going to pay for all of this stuff? Well, the employer is going to pay for it all except for one thing. If the employee requests a split sample, the employee has to pay the cost of getting their sample tested. You do not have to bear that cost as the employer. Everything else the employer pays for. You pay for the cost of the test, the initial and the confirmatory. You're going to pay for the time off work for testing, transportation costs, etc. You're on the hook for everything else. Counseling programs, the Act does not require an EAP or similar program. However, if you already have one in place, if you offer that type of counseling or some type of rehabilitation program, then the information regarding these programs must be placed in your written policy. So we have someone tested, we get a positive result, now what? Well, a confirmed positive drug or alcohol test in violation of your written policy opens the door to allow legally protected discipline. You can now discipline for these things. So people were a little bit concerned about doing this in the past because of litigation, but now, as long as you're following your written policy, get the confirmatory test, you can take adverse employment action. Refusal to test, we're going to talk about this. Prospective employees, how does this apply to a prospective employee who tests positive? The action in response, honestly, to a positive test is limited only by your imagination as an employer. It's whatever you want to do. It can be suspension, it can be termination, whatever, counseling, whatever. The door's open to whatever you want to do under this act. A mandatory employer provided or approved rehabilitation, treatment, or counseling program, and it may be required as a condition of continued employment. So if your adverse action is, okay, you can continue employment, but you have to go through a counseling program, that can be part of your written plan as the employer. Look at this, the cost may or may not be covered by the employer's health insurance. So if your health insurance does not cover this program, the employee who tests positive is required to go through this treatment is on their own. Suspension, with or without pay, it's up to you. It can be a designated period of time. Up to termination. How about prospective employees? You can obviously refuse to hire a prospective employee who tests positive. And then the law goes on to say, or any other adverse employment action in accordance with the employer's written policy. So again, it's up to you, whatever you want to do, and it talks about including any collective bargaining agreement provisions. Okay, remember I said we now have a definition of safety-sensitive employee? Well, we do. Again, if you're in the private sector, it really does not come into play because that was something from the Twig case, but here is our definition of a safety-sensitive employee. It's an employee in a position where an accident could cause loss of human life, serious bodily injury, or significant property or environmental damage. One of the areas that always came up was property damage, safety sensitive. Well, according to the legislature, we now have, yes, it is. So I think perhaps those who are still under the Twig holding can perhaps use this definition in determining whether to randomly test those in safety sensitive positions. The Act goes on to say that we must comply with any applicable state or federal law. So if there are other state and federal laws, the DOT has their own set of regulations. Some of those different areas that you may have to comply with, you still have to comply with those. This Act does not abrogate your responsibility to do that. In a safety-sensitive situation, the Act says an adverse employment action may include permanent removal from the sensitive position and reassignment to an available non-sensitive position with comparable pay. So again, you can do whatever you want to in that situation. Or any other action, here we go again, consistent with the employer's what? Written policy. Now, keep in mind here, if any of you work with union facilities, keep in mind there are collective bargaining agreements out there. So when you're renegotiating your collective bargaining agreements, you need to make sure there's nothing there that's going to be inconsistent with the Safer Workplaces Act, because in the contractual provisions, the collective bargaining agreement would come into play in those situations. Okay, legal protections. What kind of legal protections do we have? Well, remember, adverse employment actions may only be taken after a confirmed positive alcohol or drug test. The Act goes into quite a bit of detail of what you cannot be sued for, including actions based on results of a confirmed positive or refusal to submit to a test. So refusal to submit for a test carries whatever your plan says. If you refuse to submit to a test and your plan says it's termination and you're legally protected in that situation. Failure to test. So an employee cannot bring a lawsuit from you saying, well, you failed to test or you failed to test for this particular drug, etc. You have protection for that. You can terminate or suspend your program at any time. It's up to you. You have liability protection for that as well. The only exception to that, and this, you would have to be a really bad actor if you fall under this, because the only exception to this is there's no cause of action against an employer unless it's based on a false positive test and the employer had actual knowledge that the test was false. So again, you'd have to be a bad actor to fit under this. There's a rebuttable presumption that all the tests are valid. It's up to the employee to prove that it is not. And there's no liability if you relied in good faith upon a false positive test, because sometimes that does occur. There are such things as false positive tests that we get. So if that happens and you act on it in good faith, you have liability protection. It's only for the bad actor who has liability. The Act says there's no claims for defamation unless there's inappropriate disclosure and you meet the other elements of a defamation of character claim. Okay, again, remember, I know I've said this over and over, but I want to hammer this into you. Safer Workplaces Act demands strict compliance with both your written policy and the statute. You've got to follow it exactly. Yes, sir.
Yeah, we're National Incorporated. We've got locations all over the world, and we generally refer to the corporate policy. So we may not have a site-specific policy here in our West Virginia site. We just say we follow the corporate written policy. Is that adequate, or with this new rule, do I have to have my own West Virginia-specific written policy?
I would have my own West Virginia-specific written policy. Do you guys agree? I think you need your own West Virginia policy. I think if you start relying upon a broad base that is not in strict compliance, because the Act says you have to have strict compliance, I think you need your own West Virginia-specific policy.
Even our CPA refers to that. They basically say you're part of the Ashland Standard
Right.
policy. We've been enforcing it for some time. I mean, we've been doing randoms.
Well, but you're under a collective bargaining agreement, so that's a little bit different because you're under a collective bargaining agreement. Your collective bargaining agreement is going to control, so if you want to change that, you're going to have to incorporate that into your next bargaining agreement if you want to change this West Virginia-specific policy. Okay, confidentiality. There's a provision in this Act regarding confidentiality of the results of the drug testing. All communications received relevant to drug or alcohol tests and received through drug testing programs are confidential. So you can't disseminate positive tests to the world is what this Act is telling us. They are confidential. Not used or received in evidence, obtained in discovery, or disclosed in any public or private proceeding. Now, Susan Beth sent me an email with a very good question about this. There are some requirements of mandatory reporting. I think it was the nursing board, right, that it requires reporting of positive tests. I do not think this abrogates your responsibility to do that at all. I talked to a friend of mine who was very close, worked very closely with the Senate in drafting this legislation, and he said that the intent of this was to prevent employers from using this as giving bad references because something tests positive. I know Steve had a thought on this also that was to prevent employers from being drug into lawsuits regarding the positive tests, et cetera. So, but I do not think it in any way abrogates, because recall, we had the other provision that says you must still apply with any other applicable state or federal law. So I think if there are reporting requirements to boards or whatever, I think you still have to do that, and the confidentiality provision does not prohibit you from doing that. Now it goes on, there's an exception to that, and it says the exception is in a proceeding related to an action taken by the employer under the Act, and it specifically refers to unemployment compensation, workers' compensation, or other litigation. Okay, how about notices and forfeiture? If the program is implemented in accordance with the Act, including notice, education, and procedural requirements for tests, then you may test for alcohol and drugs. So again, you're going to have to do, and we'll talk about this a little bit later, but you're going to have to educate your workforce, and especially your supervisors, regarding your new policies. If a drug or alcohol is found at a level prescribed by the policy, then the employee may forfeit eligibility for unemployment or workers' comp indemnity benefits. And that has some significance to it, because when I get to the workers' comp section, I'll explain what I mean by that. Now, again, remember, if the level is in there and you test in accordance with your policy, the person may lose their right to their indemnity benefits, but they may still be entitled to medical benefits in the workers' comp claim. I think the workers' comp portion of this is going to get a little tricky, and the interplay between those two is going to cause a little bit of litigation for you guys. And for workers' comp, it says the person has to be injured at the time of the intoxication. And refusal to test is the same result, results in forfeiture of your benefits as well. So if you refuse to be tested, you forfeit your right to unemployment compensation benefits and the indemnity portion of your workers' compensation benefits. All right, here's the workers' comp. Post-accident testing with workers' comp is a different scenario. In 2015, the legislature changed West Virginia's law regarding drug testing with workers' compensation claims, and it's in Section 2342, which is part of our Deliberate Intent Act. This act says that you can test someone if you have a reasonable, good faith, objective suspicion that someone's under the influence. Oh, wait a minute, I thought we just got rid of that. Oops, it's still in the Workers' Comp Act. Don't know how that's all going to pan out, because the Workers' Comp Act says you have to have a reasonable, good faith, objective suspicion to drug test. And guess what else it says? It has to be a blood test. So we have the reasonable, good faith, objective provision standard in the Workers' Comp Act. It has to be a blood test. And if it's alcohol, it has to be a blood test within 2 hours of the accident. And my guess is, I don't know, those of you who actually work and do this, I think it's going to be very difficult to get blood from someone and test it within 2 hours of a work-related injury. Maybe I'm wrong about that, but I don't know what your experience has been with that.
Never seen it.
You haven't? We have one. So, oh, I know which one it is too, right? Yeah. Now, for drugs, under the workers' comp statute, there is no 2-hour requirement, but it still has to be a blood test. So under workers' comp, remember, it has to be a blood test. This is what the workers' comp law says. Reasonable, good faith, objective suspicion, a blood test taken within 2 hours if you're testing for alcohol, and there's no such time limitation with respect to drugs. Now, what does all this mean with respect to the Safer Workplaces Act? Well, I would suggest you get the actual advice from your attorney, but I will tell you what my thought is on all of this. The Workers' Comp Act applies if you want to use that evidence to deny a workers' compensation claim. Now, the big change that was made to this statute was that if you test positive, that there is a presumption that the intoxication or drugs you're under the influence of caused your workers' compensation injury. Now, prior to this legislative change in July of 2015, there was no such presumption. The employer could get evidence that someone was positive, but still had to prove that the intoxication caused the injury. That changed in 2015. Now it's presumed that is the case. So my thought is on this, if you want to use the workers' compensation law to deny a workers' comp claim and have that outright presumption, you need to follow the workers' compensation statute. Now, does this mean if you have a program that tests saliva, urine, all this other stuff, can you still use that in a workers' comp claim? I think so, but I don't think you get that presumption. I think you then have to argue that this intoxication caused the injury. And folks, I think that's not easy to do. It's a difficult.
And that would be for the indemnity only, correct?
Yes. Yes, good point, Steve, because that's a good point. Because remember that the Safer Workplaces Act only results in the forfeiture of indemnity benefits. So I think if you use saliva, urine, hair, whatever, you get it positive, you then prove that that caused the injury. I think you forfeit your indemnity benefits, but maybe not your medical benefits. I don't know. I would still argue an outright denial of the claim in that situation, but that's another argument that I think is going to come up in this.
Tony, quick question. I've run this by Steve, and I'd be curious of your observation. If you do not have a policy yet implemented under the new law, and you have a positive drug test, you have reasonable suspicion, or you just were one of those employers that post-accident tested, and you had your analysis positive for cocaine, do you believe that your analysis could be interpreted by a medical professional and still use that to prove that intoxication was as an affirmative defense for a workers' comp injury?
I think you could. I think you could still use that evidence and argue that the intoxication caused the injury, the testing positive for cocaine.
Do you agree the result itself can't be used to deny a claim? You
Correct.
still need,
No presumption.
There's-
no presumption.
Right.
So you still need medical professional testimony.
I agree.
That affects.
Yes, I agree with that.
Thank you.
So how about in the workers' comp situation, refusal to test? And I don't want to get too far down into the weeds on this workers' comp stuff, but this is another one I think could be quite interesting because we have this very unique anti-discrimination provision in West Virginia that says you cannot terminate someone who is receiving or eligible to receive workers' compensation benefits. And I don't know how that's going to come into play with this new law, but I could see an issue there because, you know, that law says if it's a separate dischargeable offense. I don't know. I think it's going to get a little bit dicey with how the workers' comp interplays with this if you want to use this evidence in the workers' compensation side.
It has to be wholly unrelated to the claim.
Right. And, you know, we always, over the years, have argued, you know, how about someone who violates a safety policy and injures their back? Is that wholly unrelated to the claim? Well, no, that's what caused the injury. So so some of this stuff I think you're going to see come up. There's going to be some litigation, and I think there's going to be some interpretation that still has to be done of how these two acts. But my opinion on it is, again, if you want the presumption that the intoxication caused the injury and to be able to outright deny that claim, you have to follow West Virginia Code 2342. You still may be able to argue that the person was injured because of the intoxication, but it's going to be the burden's on the employer to prove in that situation. All right. Just when you thought it was safe to go back in the water, guess who pops up? Along comes OSHA. How many people have heard of OSHA's electronic record keeping rule? Anybody? What do you know about this electronic record keeping rule?
Well, I know that it's some of the rules and things that have come out and have to be very stringent. And especially, and I think it tied in some with, we were talking about some of the random reasonable suspicion testing.
Yeah, this electric record keeping rule, I think went into effect on January 1st of 2017. Now, this was a rule that OSHA promulgated to deal with electronic reporting of injuries and illnesses. And it applied to a certain group of employers, I think certain high-risk industries, and then employers, I think, greater than 250 employees will require you to electronically report your injuries and illnesses. Now, this has been delayed over and over again, and it has been delayed once again. The latest I saw on this was that OSHA was still looking at a few things. I think the administration is looking whether this thing's going to go forward or not, but there's a portion of it still in play. And I'm here talking about drug testing. What in the world does this have to do with electronic reporting of your injuries? Well, OSHA has an anti-retaliation provision. Which is there, and I think it remains, and it went into effect on January 1st of 2017. Now, what does drug testing have to do with electronic reporting of your injuries? Well, OSHA decided that employees were concerned and maybe not have been reporting injuries because they were concerned of being drug tested. Now, if you read the regulation of this rule, there is no mention of drug testing in it whatsoever. But if you read all the commentary that OSHA provided regarding this rule, it's about nothing other than drug testing. So OSHA was concerned that employees were not reporting injuries or illnesses because they did not want to be drug tested. So OSHA, in this commentary, addressed post-accident mandatory testing and said employers are required to implement a reasonable procedure. You cannot deter or discourage employees from reporting an injury, and they considered it an invasion of privacy. What's this sound like? It's almost like OSHA read twig and said, we're going to implement it. if you read their commentary, it's a reasonable suspicion standard. And they talk about it being an invasion of privacy. Now, in OSHA's defense, what they do state in the commentary is they want to prohibit employers from drug testing people who have bee stings or, pick up something and injure their back, the injuries that are, but, do you think that really prevents employees from reporting their injuries because they're going to be drug tested?
Only the ones that have something to worry about.
Yeah, and the thing about this rule is that it allows the compliance officers for OSHA to assess monetary penalties against employers who do not have a reasonable policy in place. Stay tuned what's going to happen with all of this. I have talked to a friend of mine who works at OSHA, and I don't think they have actually had any real direction on what's going to happen with this. A lot of stuff that OSHA has been doing has been delayed or permanently delayed by the new administration. There was a rule regarding record keeping which extended OSHA's authority to enforce from 6 months to 5 years. That's been permanently delayed. It's gone. The beryllium dust rule has been delayed. I think it may finally have gone into effect. There was a new silica rule that came out. That's been delayed. So a lot of this OSHA stuff is still being considered, and the agency said it needs more time. So I think you may see, obviously I don't have a crystal ball, but my guess is you may see that go away eventually. All right, next steps. What do you need to do? Who said that first? All right, here. Which color of my wonderfully pastel Brick Street mugs would you like? Pink one? All right.
Thank you.
Mm-hmm. Okay, you need to have a written policy. So if you have a current policy in place, you need to revise it to make sure it strictly follows the Safer Workplaces Act. Remember, we have strict compliance and your policy controls everything. So you need to have a written policy. Go shopping. Go to... All right, I like to shop. Melissa and I are side by side in office, and we truly are like the odd couple. I'm the one who prefers to shop. I have like 20 pairs of shoes in my office, and her office is all very neat and tidy. We are the true odd couple. So, seriously, go shopping. Breathalyzer. I mean, go across the street to CVS. I think there's one right there. Home testing kit, perhaps. Whatever your policy says you're going to test. I know one thing I saw recently was the saliva swabs. Very inexpensive, very quick way to test for drugs. I think those $25 or $30 is what one of those swabs costs. So there's some very inexpensive methods out there. And again, you can test whatever you want. So it's your decision. Identify your service providers. You need to make sure you have this in your policy. Identify who's going to do that. Your MRO, make sure that is identified. Make sure you get one of the 3 approved labs that I mentioned earlier. Who can tell me the 3 labs I mentioned earlier? Clea, there's one. I need somebody to tell me all 3. I'm going to give you another. Wow, good. Which color would you like? The light blue. Mm-hmm. Train supervisors. I cannot stress the significance of training your supervisors under the new Safer Workplaces Act. Educate your employees and make them sign acknowledgement forms that they have reviewed and read and are familiar with your new drug testing policy. Very important that you do this. All right, any questions? So I did some research and I compiled my list of excuses. These are actual excuses that people have given for testing positive in a drug sample or alcohol. Smoked pot at Christmas party last year. The test was in October, 10 months later. I was told I'd be laid off for 4 months. It's not my fault you called me back in 1 week and then drug tested me. I buy shampoo from China, and there are opiates in the shampoo. So be careful about buying your shampoo from China. I didn't make these are real. I was carrying a joint in my pocket. I use hemp oil to make salad dressing. I kiss my girlfriend and she uses cocaine. My hairdresser is a cocaine addict. My hair must have absorbed it from her hands. I ate poppy seed muffins. Unfortunately, he tested positive for marijuana. Here, this is one of my favorites. This guy actually brings in a receipt from Burger King. I ate a Whopper. It has sesame seeds. And my favorite, I should not have used another person's urine. So be careful whose urine you use to be tested. So. Any questions? I think you can do it as long as it's in your policy. Make sure it's in your policy, but yeah, I think you can do it. No reasonable suspicion, unless it's workers. Remember, we still have that workers' comp thing out there.
Excuses, I had one where I attended a party where there was marijuana being smoked, and I didn't partake in it.
But everyone else was. I've heard that one. Yes, ma'am.
When you're talking about the prescription drugs, is that something, and then they say that they're on a prescription drug and that's why they test it, is that something that should be revealed prior to drug testing? I mean, could you put it in your policy to say if you're on medications, you need to let us know so we can determine if you can work under that condition?
I think you can have. I think your policy can have that. Can be that specific. I think this law allows your policy to determine what drugs are detected or not detected, whatever, and whether the person can operate. So, for example, if you have someone who's operating heavy machinery, you do not want them taking narcotic medication. I think you can put that in your policy.
One other thing, in our other states, our commissioner can make like regulation changes. Is that something that could be done here without opening up Rule 23?
I mean,
or Rule 20? That would coincide with new legislation?
I think you would have to reopen Chapter 23 of the Workers' Comp Code and change that in some manner if you wanted it to coincide with this. I think when that provision about allowing someone to identify information, I think that is, if you identify to someone, hey, I'm going to send you for drug testing, I think at that point they get the opportunity to say, well, wait a minute, I'm on a prescription medication for. But I also read this to say that you can determine what medication someone cannot be on operating machinery or whatever in your facility. Steve?
Do you have any concerns that this law, given its breadth, might entice employers to possibly violate the American with Disabilities Act?
That's a very good point. Possibly. I mean, this act, the breadth of it, I mean, is enormous if you see how well it's written. I think you're going to see some litigation come up, and I think it all depends on how, I always tell people, I think we have to use a common sense approach to this and be careful. But I think, you got to look at some of these other laws to make sure you're not violating them in some way. Susan Beth?
So if you have reasonable suspicion testing currently in your policy, and what I hear you saying is you could technically take that out if you wanted to. But kind of going back to his thing, employees, they get really upset if you just, I'm going to drug test you. You've never done that before.
Right.
I'm just going to drug, well, why? I'm just going to,
Right.
And it's not, you're not talking about random, you're just, so do employers continue, should we continue to have kind of reasonable suspicion type of things? Because I just don't think the police are gonna understand that shift all of a sudden.
Well, I think you raise a good point where you have been basically doing no testing, so to
Yeah,
speak.
we're doing it.
I know you're right, but not to suddenly going in and saying, hey, I want every single person in my facility tested. I think that's going to be a big change in culture. So,
But you do have a safety sensitive definition there.
right.
That would justify an expansion of testing that wouldn't have been done before.
Yeah, but I still may have that office worker who's pushing a pencil.
Right.
I may have tested before, that's reasonable suspicion.
The problem I see, and the reasonable suspicion is not a bad thing, but it's what is it? How well do you define it, and how do you train your people to recognize it and identify it? What reasonable suspicion is? So yeah, but I think that's going to be a big change you're going to see, especially if employers start doing a lot of testing across the board because of the fact that it's absent from this law whether you have to have that or not. So I don't know, Steve. Do you have any?
As Tony's pointed out very well, there are lots of other laws you have to think about. Tony pointed out that OSHA regulation, which not many people are aware of, but which is very troublesome. But there are also issues, I would suggest, under the Human Rights Act, that if you start picking on one person without any reason whatsoever, and it's only that person turns out to have a protected characteristic. They're over 40, they're female, they're Muslim, whatever. They're going to say, you're picking on me because of that protected characteristic. So I think, in my mind, this act is a bit dangerous for employers.
It could be.
They may be tempted to take the breath literally and test without any reason. I still think as an employer, better protected. I'm saying if you're going to have a testing of a person, you should have some criteria so that the person. Exactly, but.
Post-accident, pre-employment, those are the reasons.
Right, if you're talking about a current employee, I think you should have some stated criteria that avoid the discretion being so wrong that one person is going to be convicted on.
Yeah, that's a good point because think about it, if it ends up being one person 3 times in a row or whatever, and then you ultimately on the 3rd time that person's positive, it will look like you're singling that person out, and it could be troublesome. As you know, we have the West Virginia Human Rights Act, which is interpreted a bit more broadly than the Americans with Disabilities Act.
That's why you do a percentage or you do massive random retest everything.
Well, Henry pointed out earlier, you do have the safety sensitive if you want to throw that, incorporate that in there, that we're going to do random testing on folks who fit under this definition of safety sensitive or whatever. So I think you have to be, I would caution people if I was their counsel and doing this to have some parameters and be careful with how far you go with your program.
You can use drug testing agencies. There's third-party administrators, other companies you can use to do the testing. You do the sampling, all that, you do the lottery as well.
Right.
Pick 20% of your workforce or whatever, but I didn't make that determination.
But the next step I would advise you all to do is get with your attorney who assists you with your labor and employment issues and get a policy put together quickly that conforms with this act. Anybody have any more? Yes.
You mentioned that the act says that your policy, the written policy must be provided to employees and also available to prospective employees.
Correct.
Both.
Correct. Yes, ma'am.
What's a prospective employee?
Someone you're looking at to hire.
So, does the act say anything about at what point?
I don't think it defines that. It just says a prospective employee.
Could it
So
be right before you test them, though? Wouldn't that make more sense? Because you don't test everybody that's a prospective employee.
well, keep in mind it says you just have to have it available to the prospective employee. So yeah, it probably would make sense prior to. Because are you thinking like post-offer or?
Well, that's what we do now. And that's really the only testing we do.
I think I would err on the side of caution prior to doing it. I would make them aware of we have
They
this.
already get something, so just those.
Yes, ma'am.
Do you know what other states their policies are? Are we falling in line with what other states are
we are pretty much in line. A lot of states do not, I know some other states have acts similar to this, because this was modeled, I believe, after another act. But a lot of the states that I see, they don't get this specific in this much detail. I mean, they do. I don't know if you guys have any experience in any other states, but I don't see the level of detail that this one has in some jurisdictions.
Also, don't think the workers' comp overlap is the same.
That's very true. The workers' comp overlap is not the same. Yeah, we were way behind in adopting this presumption. If you do test positive, most other states already had that provision in their workers' compensation law, and we just got it 2 years ago.